Good evening, everybody. Like Adam said, my name's Pete Reinhardt, and I primarily practice in employment law on both sides, as well as some commercial litigation and some intellectual property litigation. So let me start with this. You all should have a relatively new, shiny, written grievance policy somewhere. And what I want to talk about is what happens when an employee actually exercises his or her rights under the grievance policy. I want to give you some idea of how the policy actually works in practice, make some suggestions to you about how it should be implemented, and give you something to think about in terms of does it actually make economic sense to follow the grievance policy if an employee files a grievance. Have any of you been through a grievance proceeding under the Act 10 grievance policy yet? Well, the reason I agreed to do this presentation, because I'm a good guy, first of all, but was because I just spent 2 days this summer representing an employee who had filed a grievance under the grievance policy. And we had 2 full days of a hearing, 16 hours of a hearing. We had 12 witnesses, 50 plus exhibits, and the combined fees probably between me representing the employee, the school district on the other side having an attorney represent them, and an independent or impartial hearing officer probably came to about $60,000. And so I put that as the background for you to think about as I describe how these things actually work. Now, if I can I want to impart 2 primary things to you, and I'll get to those because they basically say if you can take 2 things away from these presentations, it's a pretty good presentation. So first of all, what's required? This is a nuts and bolts refresher, and this is statutory. You have to have, if you're a local government unit, and now that the unions are gone except for very limited things, a written grievance procedure addressing 3 things: employee terminations, employee discipline, and workplace safety. Today I'm going to talk about employee terminations. Okay, that's going to be the main thing. Now, in addition, the grievance procedure has to have a written document specifying the process and include a hearing before an IHO, an impartial hearing officer, and an appeal right to the highest level of the governing body. So, with that as a background, here's what I will tell you about what you should include, and then I'll go to what you should not include. There's 3 things you have to have as these things are carried out. First of all, when the employee is contesting a termination or a discipline, who has the burden of proof, the employee or the employer? What is the burden of proof? When I talk about burden of proof, I mean there's going to be an impartial hearing officer deciding whether or not the grievance should be sustained. And so somebody has to have the burden of proving that the grievance is justified. And there has to be some decision or some procedure about what that burden of proof is. Let me give you an example. You've all heard of a reasonable doubt, okay, in criminal proceedings. You could have a grievance procedure that says an employee has to prove his grievance or her grievance beyond a reasonable doubt. There's a middle level of burden of proof, which is clear and convincing evidence, or the third is a preponderance of the evidence. This should be in your written grievance procedure about what the burden of proof is. We suggest, 1, the employer has the burden of proof. And this is probably one of the most important things I can tell you, is you need to look at your grievance procedure because you might have taken it off the internet, you might have gotten it from us, you might have gotten it from somebody else, but make sure as the employer that the employee has the burden of proof. The burden I would suggest is clear and convincing evidence or a preponderance of the evidence. And what does the employee have to prove to sustain the grievance? I suggest the employee has to prove that the termination or discipline was arbitrary or capricious. What does that mean? That means that the employee has to prove that there wasn't some rational basis or reason for the termination. An example would be a termination that was based on the fact you didn't like the employee's style of haircut or color of their eyes or things of that nature. What not to have. The grievance proceeding I was involved in, the burden of proof was on the employer, the school district. That is something you should absolutely, positively, as a local governing body, avoid. You want to make sure as you look back through your policy that the burden of proof is on the employee and not the employer. Because you don't need that. You want, as a local governing body, to have the process aimed towards you prevailing in the grievance. You have to follow the process, but you want to make sure that you're likely to prevail. Even worse in the grievance procedure I was involved in was that the employer was required to establish, by a preponderance of the evidence, just cause or cause. In other words, the employer had to establish that there was some good reason for the termination. Now, that's the standard that used to exist under collective bargaining agreements, that the employer has to establish just cause. And there's no reason for you as an employer to put that burden on yourself. Have the burden of proof on the employee, and the burden of proof on the employee is that the employee has to prove that it's arbitrary and capricious action. So let's, before I get to this, the grievance proceeding is really a trial. It's a quasi-judicial proceeding with burdens of proof, evidence, which includes testimony of witnesses, introduction of exhibits, arguments by the parties, a written decision, and the right to appeal. And the problem with many written grievance procedures you're going to see, and again, I'd ask after this presentation, you should go back and look at your grievance procedure, is that there are many, many details about how this thing pans out in a practical sense that aren't included there. So the first thing that you have to have as you have the grievance procedure is, I have independent, the statutory language is impartial hearing officer, which is a judge. Somebody is going to make the decision about whether the grievant has sustained his or her burden of proof as to the nature of the termination or discipline. So who do you go out and get as an impartial hearing officer? Usually, there are attorneys who are willing to serve in that function. The parties have to agree. The grievant and the employer have to agree upon who the impartial hearing officer is going to be. The problem is, and this gets to the economics of the grievance procedure, is you're going to have to pay that attorney who's going to act as the impartial hearing officer. And attorneys are going to charge you between, I don't know what the municipal rates are, but when you go out to an impartial hearing officer, probably $200 to $300 an hour. And so one suggestion I have is, if you find yourself in this situation of having a grievance, you might want to suggest or ask the impartial hearing officer if he or she will agree to do it on a flat rate. I can tell you that with respect to the grievance procedure I went through this summer, probably that attorney charged $20,000. He came from out of town. He had 16 hours of trial. He had 4 or 5 hours of trial before preparation, and then he has to issue a written decision while looking at, after looking at all the briefs. The employer, not the employee, pays for the impartial hearing officer. And, well, let me get to the next slide on that then. Well, let me stay on that slide, actually. So in addition to the issue of the impartial hearing officer, you, or as a local governing body, have to decide, are you going to have an attorney represent you, or are you going to have somebody internally represent you, like an HR person? You certainly don't have to have an attorney represent you as a municipality or as a school district, but there are clearly some advantages because this is a quasi-judicial proceeding. The second thing is the employee who is filing the grievance entitled to have legal representation? And my strong suggestion is that they should be allowed to have legal representation. The problem is, whenever you get attorneys involved, it becomes more time consuming and it becomes more expensive. And that's just a practical issue. But likely you're going to have an attorney who is the impartial hearing officer, you're going to have an attorney representing the employer, and you're going to have an attorney representing the grievant. And what does that add up to? A time consuming, expensive mess. So even after you've chosen the independent hearing officer, but before the grievance, there are numerous things that have to be decided, either by the independent hearing officer, your grievance policy, or the parties. First of all, the grievant, the employee, is going to be entitled to some, or should be entitled to some information about what was the basis of the termination decision or discipline. Usually, you as the employer and the grievant are going to exchange exhibits, actually say, here's what I'm going to use at the hearing. And you'll mark them and exchange them. Usually the parties will identify who the witnesses are going to be. And then there's the question of, are there going to be opening statements by the grievant and by the employer? Are there going to be closing statements? Are the rules of evidence going to apply? And will parties be allowed to cross-examine witnesses? Now, when you look at all of this, my suggestion is, as a municipality or as a school district or as an employer, that you allow an employee to have not all of, but the full opportunity to present his or her case and his or her evidence, including an opening argument, cross-examination, etc. Because if you don't, and the grievance procedure is challenged in court later on, the employee is going to say, hey, I wasn't afforded the full due process of the law, an opportunity to be heard that I should have been afforded, and that can present another legal claim for you. So this is my recommendation. This isn't in the statute. This isn't in writing anywhere. But my suggestion is you give the employee the full opportunity to be heard and the full safeguards in terms of examining witnesses and cross-examining witnesses. When you get, I'm going backwards. So when you get to the grievance, and I hope you're getting the sense now that the legislature imposed this Act 10 grievance policy on you, and you put one in writing, but if you actually have to go through this process, it can be very time-consuming. It can be very expensive, and at the end I'm going to offer a suggestion to try to avoid this. But the purpose of my presentation is to indicate to you that, hey, there's a lot in terms of the details of how these things actually pan out. If you have one, you need to have your heads up about that, and there are some things you can do perhaps to avoid it. So getting to the grievance proceeding itself, it should be recorded. You don't have to pay for a court reporter. A court reporter is somebody who comes in with their little machine and they take down all the testimony as it's taken. But you should have some record. And my suggestion is, at the very least, you bring a tape recorder or a CD and you record the proceedings. So if there's some question later on, you can go back to that record. A couple other things that come up: where is the proceeding going to be located? And that usually happens at a town hall or school district office. Is it open to the public? Typically, the parties agree on whether or not it's open to the public, and if the employee doesn't want it open to the public with appropriate notice, it's not open to the public. Will witnesses be sequestered? Again, we're all getting back to this is really a quasi-judicial trial-like proceeding. Sequestration of witnesses mean that as the parties present their witnesses, witnesses who are going to testify after a witness are out in a different room so they can't be influenced by what a particular witness says, and I always request sequestration of witnesses. How long will the proceeding take? The grievance proceeding I was involved in was supposed to take 1 day. and it went well into 2 days. So it's going to take much longer than you think. And how does it actually work? So again, it's like a trial. The person with the burden of proof, which, as I've told you, should be the grievant, not the employer, goes first, and they have a direct examination of their witness. The employer will have a cross-examination of the witness, and then the grievant can come back and do a redirect of the witness. After the grievant goes through all of his or her witnesses, the grievant closes the case, and then the employer will put on the case with witnesses again, his or the employer's witnesses, and again, direct exam, cross-exam, and redirect. Then after all that's done, typically you're going to have the grievant allowed to put on a rebuttal case, which is to address things that the employer had brought up that hadn't been addressed in the grievance case. So that's the grievance actually proceeding. When evidence is closed, it's not all over yet. Then there's the question of how are closing arguments going to be handled? Are they going to be done at the hearing proceeding, or are there going to be written briefs? In the case I did, I think we had written briefs with a page limit of 40 pages. Again, you have some attorney writing a written brief, charging you a lot of money for the written briefs. So my suggestion is, if you go through this type of a proceeding, to actually have closing arguments that are made orally as opposed to in the written brief format. The ultimate thing that occurs is you're going to have a written decision issued by the impartial hearing officer, which will have proposed findings of fact. You need a written decision, and you should have proposed findings of fact, because the decision is subject to review by the highest governing body of the municipality or the school district, and you have to have some form of a record for that highest governing body to review in order to make the decision about whether or not it was properly, the decision was proper. Remember, I said in the beginning the statute requires an appeal to the highest governing body. So in the case of a town or a village, that's going to be a town or a village board. And typically, what is required is a majority vote of the town or village board as to whether or not the decision of the impartial hearing officer should be upheld. But again, going back to the grievance policy, the written grievance policy, a town or a village or a city or a school district should have some things in that written grievance policy about what is the standard of review when the town board or the village board or the city council are deciding whether or not to uphold or affirm the impartial hearing officer's decision, because you can really shoot yourself in the foot. We suggest a great deference standard, giving great deference to the impartial hearing examiner's decision, because you don't want to have to do what's called a de novo review of the record, which means you as a town board or village board have to look at the entire record of the proceeding before the impartial hearing officer and pay that no deference. So our suggestion is that you use the great deference standard, and your grievance procedure, if it's well drafted, should have in there what the standard of review by the town board or the village board or the city council or the school district board is going to be. But when that's done, you're still not done, because when that's done, the grievant can still file a case in circuit court saying that the whole thing was done wrong, from one, the way the hearing was conducted, to the decision of the independent impartial hearing officer, 3, to the way the highest governing body of the town or village or city or school board made its decision, to 3, the due process rights that were afforded during this thing. So here's my analysis after going through one of these grievance procedures as to whether or not it actually makes sense, and then I'm going to tell you what I think the alternative is. I was not overly enthused about how these things actually pan out. You know, it's fine in theory, in paper, according to the statute, that you give this the grievance policy. I think it was intended to be a concise, short process that wasn't going to be overly burdensome on a governmental entity. But the way it's actually going to happen, if it's done right and you have competent people assisting you in the process, I just went through, and that's anything but easy and quick and not time consuming and inexpensive. Because, as I said, one, you're going to have your time. You're going to be garnering, you're going to be getting together witnesses, you're going to be spending management time, you're going to be working with an attorney to get prepared for this grievance proceeding. Two, as a city or town or village or school district, you have to pay the impartial hearing officer. And then you're probably going to have to pay your own attorney. And I can tell you, you're looking at, even if you have a 1 day or a half day, you're probably looking at $10,000 to $15,000 to pay the independent hearing officer and pay the attorney. And I think that's on the conservative side. And that's without having any certainty. You don't know what the impartial hearing officer is going to do. That's why they're called impartial hearing officers. They're there to not have any bias either way. Now, if you did what I suggested early on, which is look at your grievance procedure and make sure that the employee has the burden of proof, and make sure that the burden of proof is for the employee to prove that the action was arbitrary or capricious, rather than the employee being able to establish, rather than the employer having to establish that there was a good reason for the action, you're likely to prevail. But that's why, again, you need to go back and look at that grievance procedure. Third, you may get through the grievance procedure and you may prevail, but that doesn't mean that the employee can't sue you for other claims. For instance, the employee can still say, hey, okay, I lost this, but you engaged in disability discrimination, or you engaged in age discrimination, or sexual harassment or gender discrimination, or fired me in retaliation for wage and hour violations. And you could end up going through a whole nother proceeding before the Equal Rights Division for the state of Wisconsin, or in state and federal court, to deal with those issues. So what is my suggestion after going through this process? I think it makes a lot of sense, before you get into the time-consuming and potentially expensive grievance process. First of all, you want to treat the employee fairly so they're not upset with you. You can terminate them or discipline them in a professional manner without making it personal, because employees pursue rights and employees sue primarily because they feel they were treated poorly, and especially at the time of the discipline or termination. But my suggestion is that a modest severance payment to a terminated employee, to avoid having to go through the pitfalls of a grievance proceeding, coupled with a comprehensive severance agreement and release, where that employee is signing off saying, I'm not going to sue you, I'm releasing you from any and all claims, including claims, any and all claims that exist up to the date of my employment, including termination of employment, including defamation claims, sexual harassment claims, etc., will be a wise and cost-effective way to buy certainty and finality with that employee. I'm not saying you have to pay him $5,000 or $10,000 or $15,000. But oftentimes an employee, before an attorney is involved, will look very favorably upon several $1,000s to sign off on an agreement to just not sue the employer. And a competent employment lawyer can assist you with preparing such an agreement to avoid having to go through those pitfalls and uncertainty and cost of the grievance proceeding. Now, do you have any questions after I just painted this very bleak picture of what might happen if your grievance procedure isn't properly drafted, or if you actually have to go through a grievance proceeding with an impartial hearing officer? Or do all of you have written grievance procedures in your handbook or elsewhere? Does anyone not have one? And are you a governmental entity? You need to have a written grievance procedure, and if you talk to us or some other attorneys who deal with municipal law, they should be able to get you a 4 or 5 page grievance procedure, or you should be able to get online, but you should have had one as of 2011. Anybody else who doesn't have one? You don't know? Well, I guess I assumed, and I'll get to you, Mr. Jarko, in a second. I guess I assumed that most towns or cities or villages would have them. You do need to have one as a local governing body according to the statute. We are more than happy to assist you, or there are other attorneys in the area who could assist you, but my suggestion is that you get one. If you have a handbook, it's often put in the handbook, but you can have a separate policy aside from the handbook. It doesn't have to be in a handbook.